So it has got exclusive original jurisdiction, meaning you can directly approach the Supreme Court and only Supreme Court has the power to hear this case. Federal issues and cases pertaining to president and vice president's election. Then writ jurisdiction, the Supreme Court has original jurisdiction but not exclusive. Even the High Court under Article 226 has the power of writ jurisdiction. So this is original but not exclusive. Then you have appellate jurisdiction where the Supreme Court will hear cases on appeal from the High Court. Okay, so it can hear cases on constitutional, civil and criminal matters if it is pertaining to any publicly important question of law. Then it can also, the accused has the convict has the right to go to the Supreme Court when death sentence is given to the person or life sentence has been given or imprisonment of more than 10 years. Then the Supreme Court can hear cases from any court on any matter under the special leave under Article 136. Then it has advisory power under Article 143 where it advises the President. The President can seek advice on any matter of law or fact of public importance or pre-constitutional matters. These are advisory and not binding on the President. Then Supreme Court is a court of record, meaning its judgments are recorded for perpetuity and is admitted in any court. Okay, its judgments is accepted in any court across India. It is recognized as a legal precedence and it is referred to in future cases. Okay, and then it also has the power to contempt, civil contempt and criminal contempt, and this contempt can punishment of imprisonment or fine or both can be given. Other functions, judicial review, it can review any law enacted by the Parliament and state legislature. It is involved in the removal of UPSC. Then withdrawal and transfer cases from the High Court. It is a final interpreter of the Constitution and it has the power to review its own judgment. Okay, these are the powers of the Supreme Court. So let's see what are the powers and functions. So first, if you look at the heading over here, it mentions exclusive original jurisdiction. When we say exclusive and original jurisdiction, okay, so original means you can directly approach the court for the first time. So we are talking about the powers of Supreme Court. Original jurisdiction means you can approach the Supreme Court directly. Okay, first you can go in your first response itself, you can go to the Supreme Court. So that is the meaning of original. First time itself. If you look at the other heading, you have something called as appellate jurisdiction. So appellate jurisdiction means the person who has put the case cannot go directly to the Supreme Court, but will go on appeal. Meaning they have to go to the lower court, then on appeal they will come to the Supreme Court. That is the appellate jurisdiction. When we say original jurisdiction, the person who wants to put the case can go to the Supreme Court directly in the first instance itself. Is that understood? So that is original jurisdiction. Okay, original jurisdiction, you have two types. Okay, you have two types. One is exclusive original jurisdiction. The other one is the original jurisdiction under the writ, Article 32. See, what we are trying to understand here is the writ jurisdiction of the Supreme Court is original, but it is not exclusive. Whereas the first one is exclusive, meaning only the Supreme Court can hear this case. No other court in our country can hear this case. When we say exclusive, what does that mean? Only Supreme Court has the power. No other court in our country has the power to hear this case. That is the meaning of exclusive. So let's put this two together. Exclusive means only Supreme Court has the power to hear this case. Original means you can directly approach the Supreme Court in the first instance itself. So there are two issues that are heard by the Supreme Court exclusively and originally. One is as a federal court or federal issues. What do you mean by federal issues? Any issues arising due to federal relationship. So who constitute the federalism of India? Who constitutes the federalism of India? It is the state and center, union government, correct? So if there is any conflict within this federal system, then they will directly go to the Supreme Court. For example, if there is any conflict between Karnataka and Tamil Nadu, which court will they go to? Directly to the Supreme Court. No other court has the power to hear it. If there is any conflict between Karnataka and central government, let's say GST issue, something is there. So if there is any conflict between center and state, directly they will go to the Supreme Court. So when the Supreme Court is acting as a federal court dealing with federal issues, conflicts, okay, then it has an exclusive original jurisdiction. No other court in our country can hear this case. Another issue where you have to directly go to the Supreme Court is dealing with presidents and vice presidents election. So any issue arising out of the election. So if there is any conflict, if somebody has, the party or whoever, the contestants, etc., okay, want to question the election, right? So that time also they will go directly to the Supreme Court. Did you understand? So these two are the exclusive original jurisdiction. So Supreme Court, you can directly go to the Supreme Court, and exclusive means only Supreme Court has the power to hear the case, no other. This can be asked in the examination. Then the next one is under Article 32. So Article 32, when we did fundamental right, I told you, deals with protection of fundamental rights. So when your fundamental rights are violated, you can directly approach the Supreme Court. Okay, so under Article 32, the Supreme Court has the power to issue writs. I have discussed this writs in detail. Okay, 5 writs in fundamental right. I'll not go into that part. But at least I hope you are able to appreciate that to protect fundamental right, the Supreme Court has the power to issue writs. Writs are orders or directions issued by the Supreme Court to protect the fundamental rights. So this is also original jurisdiction. What do you mean by original? You can directly go to the court in the first time itself. But it is not original. It's not exclusive. Why is it not exclusive? Because even the High Court has the same power. Even the High Court under Article 226. Under 226, even the High Court has the power to issue writs for the enforcement of fundamental rights. So therefore, it is original but not exclusive. All other cases are heard by the Supreme Court on appeal. It is not directly heard by the Supreme Court because Supreme Court is the highest court of the country. Unless it is fundamental rights or it is federal issue, all other cases has to come to Supreme Court on appeal. So that is the appellate jurisdiction. So being the highest court of the country, it can hear cases from any court in our country. So from any subordinate court, then they will go and appeal to the High Court. From High Court, they will come to the Supreme Court. Is that okay? So that is the meaning of appellate jurisdiction. That means hearing the case on appeal when they come from the lower court. So appeal cases can be heard by the Supreme Court in matters of constitutional matters, civil matters, even criminal matters. Okay. So appellate jurisdiction, we'll just discuss a little bit. We'll not go too much into the technical aspect of it, but just a little bit awareness about it. So on any constitutional matters, if any dispute, any legal matters pertains to the constitutional issues, Like for example, the Sabrimala issue with respect to the fundamental right, or with any other aspects with IT law policy, which was dealing with privacy issue, or anything that has to requires the interpretation of the constitution. So in that case, okay, the cases that has been decided by the High Court can be taken on appeal to the Supreme Court. This has to be certified by the High Court that you can take it on appeal, because it involves substantial question of law. The High Court has to certify that this matter has substantial question of law, which requires further deliberation by the Supreme Court. Did you understand? So the High Court has to certify, then only it can go to the Supreme Court. Is that okay? So appeal on constitutional matters, civil matters also. So the High Court has to certify that there is a substantial question of law that is involved in this matter, which requires the Supreme Court's opinion. Only then it can go. Earlier there was a monetary cap also, meaning a case which has which involves more than 20,000 rupees, only that can go on appeal, but that has now been removed. There is no monetary cap. Any civil matter can be taken on appeal to the Supreme Court, provided the High Court, okay, certifies that this particular matter involves substantial question of law. Okay. Similarly, on criminal matters also, okay, it has to certify. Okay, but in criminal matters, there is also an exception. When death sentence is given, when imprisonment of 10 years or life imprisonment has been awarded by the High Court or has been accepted by the High Court. Okay, if, say, for example, death sentence was given by the lower court, which was approved by the High Court. Okay, so if death sentence has been approved or given by the High Court, or if an imprisonment of 10 years or life imprisonment, in all these three cases, the person who has been convicted has the right to go to the Supreme Court. In all other matters, the High Court has to certify that there is substantial question of law that is involved. Right. So appeal in constitutional matters, appeal in civil matters, and appeal in criminal matters. So if death sentence is given, life sentence is given, and 10 years imprisonment, so the convict has, the convict has the right to appeal to the Supreme Court. It does not require any certification from the High Court. But if you look at this, you might wonder, then High Court becomes more powerful, no? If only High Court certifies, then only they can go to the Supreme Court. That is under normal circumstance. But the Supreme Court, being the highest court of the country, can take on appeal any matter under the special leave. Okay, appeal by special leave under Article 136. So the Supreme Court is authorized, okay, under the special leave to appeal from any judgment from any court. So appeal from any judgment in matters passed by any court or tribunal under the special leave petition. So this is a residuary power. This is a residuary power, meaning it is there with the Supreme Court as a discretionary power also. So it is a discretionary power. Discretionary power of the Supreme Court. Okay. And it can be related to any matter. It can be related to any judgment, and it can be related to any court in the country. Okay. Any court in the country. Is that understood? Online student also, is that fine? So these are the appellate jurisdiction. So on all the matters, if it is certified by the High Court, under special leave, any case can be taken up by the Supreme Court under Article 136, and they can hear the case. Tribunals, high courts, any court, it can take it up. Okay. The next function and power is the advisory functions or advisory jurisdiction. So here the Supreme Court gives advice to the President, or when the President seeks advice. Rather, when President seeks advice, the Supreme Court will give or tender advice. See, on any legal matters, on any public important issues, okay, or pre-constitutional matters, when the president requires more clarity, when we say president, it is the government. So when the government requires more clarity, okay, so that time the Supreme Court can tender its opinion. I mean, it does not have any legal standing per se, meaning it does not become a law. The recommendation that is given by the Supreme Court does not become a law. Neither it is binding on the president. But in the future, if any legal issues arises from that, okay, they can always say that they were advised by the highest court of the country. So it will have weightage when there is a conflict tomorrow. But as such, it is not binding. And as such, it does not have any statutory status, meaning it does not become a law. But the advice that is tendered, okay, see, for example, when the 2G scam and all happened, okay, and there was accusation on the government that there was flawed auctions. So that time the president had made a reference to the Supreme Court, please guide us as to how the national resources should be distributed to the should be sold or given away. So when the Supreme Court advised it, it becomes legally very valid. Okay, tomorrow when the government is doing certain actions based on those recommendations, and if something goes wrong, they can always say, see, Supreme Court has advised us. So that is the main objective of it. It is mainly advisory in nature. So on two matters, the president can seek advice from the Supreme Court. What is that? One, when the matter is of public importance. Okay, when there is any question of law, okay, or any fact which is of public importance, any law or fact which is of public importance. So in such cases, the president can seek advice. Similarly, if there is any dispute that is arising out of pre-constitutional treaty, agreements, conventions, okay, engagements, etc. In that matter also, to get better clarity, the president can seek advice from the Supreme Court. All right. So in the second case, that is in this matter, the Supreme Court has to tender advice. Has to. Whereas in case of the first one, it need not provide advice. It's not compulsory for Supreme Court to give advice. Next, another one is called as the Court of Record. Supreme Court is the Court of Record. Now, what do you mean by this Court of Record? As a Court of Record, what do you mean by this? What do you mean by Court of Record is that any judgment that has been announced, given by the Supreme Court is recorded for perpetual memory. And that itself can be used to decide other cases. So whenever, like, for example, Keshavananda Bharti case. So they'll say in this particular case, the verdict was like this, it was a similar matter. So you should also consider the present case because it is similar to that. So they will quote the previous cases, okay, and give verdicts. So it is therefore called as a Court of Record. So judgments are recorded, judgments of the Supreme Court are recorded for perpetual memory, and it is admitted before any court. It means it has got legal standing. Okay, it has got legal validity. So it's almost like a law. Okay, so the judgment is enforceable. Okay, not only in the present one, but also in the future. Okay, so its judgment is recognized as legal precedents. Like, for example, protection of women from sexual harassment at workplace. So the court had come up with guidelines. Okay, and everybody had to follow it like a law. Okay, so like this, the Supreme Court gives judgment. No, it becomes a legal precedent, and it is used for legal references. Is that okay? So that is the meaning of Court of Record. Another meaning of it, or another power of the Supreme Court under the Court of Record is the power to punish, okay, individuals for contempt. Contempt means when they prevent the Supreme Court from working or undermine its integrity, okay, willfully do not follow its judgments, etc., okay, or falsely publishing reports to insult the Supreme Court, criticizing it without facts. All these are cases for contempt. So contempt of court can be punished. So Supreme Court has the power to punish for contempt of court, which can range from even fine to up to imprisonment. It can range up to imprisonment. So contempt is of two types. Contempt is of two types: civil contempt and criminal contempt. So the civil contempt is when you willfully do not obey the orders of the Supreme Court, okay, do not follow the writ direction given by the Supreme Court. So that is civil contempt. And criminal contempt is when you prevent the Supreme Court from functioning, scandalizing the Supreme Court, interfering or obstruct in justice system, prevent or obstruct, okay, the Supreme Court from functioning. So those are criminal. So scandalizing it, preventing it from functioning, okay, or interfering into the working of the Supreme Court. In those cases, criminal contempt can be put. Then other minor functions or other functions of the Supreme Court is that it has the power to review laws. That is called as judicial review. This is not exclusively mentioned in the Supreme Court, but incidentally it has been derived from Article 13. From Article 13. What does Article 13 says? If any law violates the fundamental rights, then such a law can be declared as unconstitutional. So this gives powers to the Supreme Court to review such law. That's why it's called as judicial review. Review any law, any constitutional amendments, any rules, regulations, etc., which has been passed by the competent authority like the parliament, legislature, etc. And if it violates the fundamental right, further, Supreme Court being the protector of the Constitution, right? So if anything violates the Constitution, its basic structure, in that case also the Supreme Court can declare it as unconstitutional. This power of the Supreme Court is known as judicial review. The power to review any law, any amendments, any rules, any regulations, etc. And if it is violating the Constitution, if it is violating the fundamental right, such a law can be declared as unconstitutional. Then another power that is given under the Constitution is the removal of UPSC chairman and member. So UPSC chairman and members can be removed if they are found guilty of misbehavior. Then makes the reference to the Supreme Court, which will investigate and accordingly advise the president, which is binding on the president. If they find them guilty, they will advise the president to remove the members or the chairman of UPSC, and they can be removed. Okay, then being the highest court of the country, it has the power over all other courts. Supreme Court has power over all other courts. It supervises the functioning of the other courts, high courts and even the subordinate court. So in this respect, it has the power to even withdraw and transfer cases. So as I told you yesterday, that the court cases from one state to another state or high court, etc., can be transferred. Who does that? Supreme Court. So the Supreme Court can withdraw the cases, transfer the cases from the high court. Then it is the final interpreter of the Constitution. So there is so many ambiguity within the Constitution, correct? When we discussed DPSP, fundamental right, its relationship, we discussed. that there is so much of, conflict between the articles, etc. So final interpretation of the Constitution is done by the Supreme Court. And Supreme Court has the power to review its own judgment.